Before we even hear the first word from the judge, let me tell you something. This courtroom session is about to deliver 3 completely different eviction stories, and each one exposes a different side of landlord-tenant law that most people never understand until it's too late. First, we have a bank foreclosure case that turns into a legal puzzle. The bank bought a home at foreclosure, but there's already a tenant living there with a lease that runs until 2026. That raises a massive legal question. Can the bank evict someone whose lease they didn't even sign? Then we move into a second case where a tenant admits something that almost instantly hands the landlord the win, and the judge explains a brutal reality about eviction law. Even if you offer to pay everything back, the landlord can still remove you. And finally, the third case escalates dramatically. A tenant hasn't paid rent for 6 months, and the judge calculates a staggering $6,700 judgment right in the courtroom. But what makes this entire hearing fascinating is the judge herself. She doesn't just issue rulings, she walks through the legal logic step by step, explaining the system in real time. So the question is, which tenant actually has the strongest position here? Who made the biggest legal mistake? And which case ends in a surprising twist that no one expected? Let's step inside the courtroom and watch how these cases unfold.
That's a U.S. Bank Trust as a trustee for Velocity versus Joe Madrid and others. Do I have someone here on behalf of U.S. Bank?
Yes, Trevor Scholes here on behalf of the plaintiff.
Good afternoon, Mr. Scholes.
Good afternoon.
I do have someone here on behalf of the defendant, Joe Madrid.
Yes.
Good afternoon, Mr. Madrid. Thank you for being here.
Hmm?
All right, and Mr. Scholes, why is this case being filed? Or why was
So this is a post-foreclosure eviction. The plaintiff purchased the property at a foreclosure sale on July 1st of 2025 for $225,000. A 90-day notice to vacate was sent certified mail September 24th, 2025. And plaintiff is only seeking possession. However, there's a lease that appears to be a legitimate lease, and it's not set to expire until September 30th of 2026. We have not been able to verify that Mr. Madrid has been making rent payments, but we also haven't been able to verify that he hasn't. So this is just kind of a weird one. We've sent requests to get proof of that. So I'm not sure if Mr. Madrid can show statements or anything that, because if he's been paying his rent, then he's not in violation of his lease, and therefore we have to allow him to stay and finish out his lease term.
Right here, the judge has already spotted something extremely unusual about this case. Normally, foreclosure eviction cases are straightforward. The bank takes ownership of the property, and the occupants are ordered to leave. But this situation is completely different because Joe Madrid isn't the homeowner who defaulted on the mortgage. Instead, he's what the law calls an innocent third-party tenant. That means he signed a lease with the previous property owner, and legally speaking, that lease might still be valid even after the foreclosure. In many states, foreclosure does not automatically cancel existing leases, so now the bank finds itself in a strange position. They technically own the property, but they may also be bound by a lease agreement they didn't create. And here's the big mystery. The bank doesn't even know whether Mr. Madrid has been paying rent or not, so the entire case is hanging on one key question. Is the tenant actually in violation of the lease, or is he completely protected under the law? Let's see how the judge untangles this.
So, just so this is a strange one here, Mr. Scholes.
Yeah.
Property
Yeah,
got foreclosed. Mr. Madrid was not foreclosed upon. He has an independent lease. So
Correct.
he's our third-party purchaser for value. Okay.
Correct.
All right. Do you know who leased it to Mr. Madrid?
Yeah, it's MAG Construction, MAG. We requested this information from them. They did not provide it to us. And of course, we couldn't force them to. So we don't know if he was paying rent to them or not. So yeah, it's just kind of a weird one. We just haven't been able to confirm. So I thought maybe Mr. Madrid could shed some light on that.
What's that?
Mr. Madrid, you're not required. I'm just sort of thinking this through.
Oh, okay.
That's a weird situation.
Yeah.
Yeah, it's super weird because it's like a post foreclosure eviction, but
Yeah.
could potentially be like non-rent paid. So it's an odd one.
Because the bank has title, so you have standing. It's just what's the cause of action?
Right.
You
Well,
don't, because you're not y'all weren't a party to the lease,
correct.
but you were bound by it because it runs with it. Mr. Madrid had nothing to do with it. Mr. Madrid, I'm sorry, we're kind of talking out loud here legally. I'm thinking it through, right? Like you're what's considered under the law right now in the world of that, you're like an innocent third party, right? You were not the original holder of the land. It sounds like through no fault of your own, someone leased it to you. You've been in that lease. So Mr. Scholl's position is that they don't really know if you're in good compliance with the lease or not because they were not the lessor to you. They bought the land through foreclosure, and then it is the rule in foreclosure that if there is a lease existing, it runs with the new title owner. So Mr. Scholl's client, essentially, they inherited a lease.
What the judge just explained is a really important legal concept called a lease running with the property. In simple terms, when a property changes ownership, even through foreclosure, certain legal agreements tied to that property can transfer to the new owner. That means the bank might now be stuck honoring a lease they never agreed to in the first place. Imagine buying a house at auction and discovering someone legally has the right to live there for another year. That's exactly what's happening here. But there's still a big unknown. The bank has no record of rent payments, so the situation becomes legally awkward. If the tenant has been paying rent, he might be fully protected. If he hasn't, then the lease could be considered breached. And the judge is basically thinking out loud here, which is fascinating because we're watching a legal problem get solved in real time. This is one of those rare courtroom moments where even the judge admits the case is unusual.
But they weren't a party to it, so they don't have a copy of it. That's all.
Yeah. And
Mr.
I
Scholl,
mean,
have you seen the lease?
I have seen the lease.
And you said it's through 2026 through what month?
Through September, it expires September 30th of 2026.
Melted, you emailed it to him.
And under the lease, there's a requirement to pay rent?
Yes, of $2,200.
I'm just curious, Mr. Scholes, Mr. Madrid, you don't have to respond to this. Your client's not entitled to the money because they're not a party to that contract.
Right. Well,
So
yeah. I
here's
mean,
my question. Here's my question. Even if it was true that the defendant, and I don't know that, let's just say that it's true the defendant hasn't paid the rent. Do y'all have standing to sue for a breach that's not your lease? Wouldn't that be
well,
mag contractor's claim?
well, we wouldn't have. Well, so we're not seeking back rent, right? So
Right, but you're
this-
seeking possession upon a lease that's been breached.
correct.
Can you
Well,
declare that?
well, my argument would be that
Yeah.
that U.S. Bank is in privity of the contract by assuming the lease whenever they purchase the property, right? So they stand in the shoes, which subrogation is really the argument I'd use, that they now stand in the shoes of the original landlord. However, I'm really not trying to argue that today. I would really just like for Mr. Madrid to say, hey, I've been paying rent or not. I think really the best case scenario here is get Mr. Madrid to, we would like to do a new lease. We don't necessarily want to evict, but because if he's like, you're right, if he's breached that, we don't necessarily have, well, at least not in a forcible detainer action, there's no jurisdiction, nor do we really have standing to argue that he breached the lease. I agree with you there. But
do y'all want to, I'm curious, because Mr. Scholes, Mr. Madrid, court's not trying to interfere with y'all doing your jobs and your business, right? We can give y'all a private moment if y'all want to talk to each other completely outside of the purview of the court.
that would be great. Yeah.
Mr. Madrid, you don't have to do that. Would you at all be interested in talking to Mr. Scholes in a private room about kind of the strangeness of the situation y'all got?
Yes, I will.
Why don't we do that, Stephanie? Give my clerk a moment. She's doing a wonderful job. This is, I think, her third solo docket. And we all know the fun of Zoom and breakout rooms, but let's give y'all of that. And how about, we'll just let y'all go into a session. I'll do some private work here. When you're done, let me know. If you need to proceed, we can, but
What just happened here is actually a really smart move by the judge. Instead of forcing an immediate ruling, she's encouraging both sides to step away and negotiate privately. Courts do this all the time when a case is legally messy, or when a simple agreement could solve everything. Because think about it. If the tenant has been paying rent and the bank simply wants a new lease agreement, the entire case could disappear without a fight. This approach saves everyone time, legal fees, and stress, and it also highlights something interesting about courtroom reality. Judges are always trying to create winners and losers. Sometimes the goal is simply to help both sides reach a practical solution. Now let's see what happens when they come back from that private discussion.
Yeah, that's a funny,
Yeah, it's
That's
an
a
odd
funny one.
situation. Yeah.
it's a very odd situation. I'll also give y'all this. If parties end up coming back, let's say y'all want to take a little more time, we could grant a continuance here, Mr. Scholes, just because of the
Okay.
situation that's going on. So let's get y'all a room, let y'all discuss some things. Come back, let me know what y'all come to, because that's why I love doing this job. You get 99 cases that fall within a very, like, I ask 6 questions, we get there, and then I get one, and I'm like, wait, you literally, every question is a different answer. Huh.
Yeah. Yeah, it's
That's a
awesome
law
for me
school
too.
question right there. That's,
Yeah.
you got
Yeah,
some
it's cool for
fun.
me too, right? It makes work fun for, like, this is where, you practice creative solutions.
I'm kind of like, this is almost like trying to feel like function law back in the day when it was if, but, bore, then, and you were literally
Yeah,
back and forth
but
between
it's bad whenever there's like no case law, right, for guidance. So
we occasionally get justice cases that go up to the Court of Appeals and to the Supreme Court. And it's always pretty shocking. Like, really? And I'm like,
yeah,
listen, we
yeah.
had a
I'm not sure
novel
I'm not
situation.
sure we're trying to litigate this one that hard.
No, but huh. All right. There we go.
All right.
So you guys join that. That's completely private. It's not on YouTube at all. We'll just be in recess. When we all come back in, we'll come back.
All right. Thank you, Your Honor.
Okay, absolutely. Stephanie, we'll just consider this a recess so we can turn our cameras off and we'll just hang out on Zoom and let them come back. Thank you. Welcome back, Mr. Scholes. We'll give Mr. Madrid a moment. He may still be in the breakout room. Well,
It looks like he left.
Yeah, he might not join. I told him we were gonna. I think we're just gonna non-suit this. He's got a mother with dementia in that house, and I don't see any reason to not let him finish out his lease. So we'll just try to work something out outside of the court.
That ending is probably not what many people expected. Instead of pushing forward with the eviction, the bank's attorney just decided to drop the case entirely. And the reason adds a very human layer to this story. The tenant is caring for a mother with dementia who lives in the home. So rather than forcing the legal battle, the bank chose to work things out privately and allow the tenant to stay through the lease. It's a reminder that sometimes legal cases aren't just about contracts or technical rules. They involve real people and difficult life situations. But now the courtroom moves on to a completely different type of eviction case. And this next one is far more typical and unfortunately much tougher for the tenant.
Mr. Scholes, that seems very, very reasonable given, especially all the kind of the strangeness with that. So thank you. Really appreciate that.
Thank you,
All right.
Your Honor.
Have a great afternoon. We appreciate it.
too.
And then our final matter, 26247, was also, that's a DWAP. We didn't have anyone show up for that one, Stephanie.
Okay, perfect.
Have a good afternoon. Thank you.
Thank you, you too.
Ms. Garza, tell me why this case was filed.
Yeah, so we're here for payment of rent. We are missing February's and then obviously the prorated for today in March.
How much is the monthly rent?
It's gonna be $17.29. And
17.
then the prorated for today or for March till today is $167.32.
Is there any subsidy on that 1729 or is all of it owed by the defendant?
All of them is gonna be I'm sorry, say that again.
Is there any subsidy? Does the landlord directly receive payment from the government on the rent?
Oh, no.
Okay,
Sorry.
so
I just
defendant owns all of it. All right. Was your property under the Federal CARES Act?
No, ma'am.
And was this the first time in February that the defendant was late on the rent?
In February, yes, but not in like the term that he has been here. We also sent him a notice to pay rent or vacate on 2/5, and then we also sent it via certified mail too. So via email and mail.
Okay. So you sent him a notice to pay or vacate February 5th and you emailed that you both mailed and emailed that?
Yes, ma'am.
Okay, that's fine. Good afternoon, sir. Thank you for being with us. So Mr. Merritt, my first question is the monthly rent correct? Is it $1,729?
It is.
Okay.
Yes.
And then Ms. Garza says this is a recent situation, but is it correct that February and March rent remains unpaid?
No. Well, wait.
Okay.
February, March, yes. Yes.
Okay, so February and March remain unpaid.
What you just heard is one of the harshest truths in eviction law. The tenant admits that February and March rent are unpaid, and legally that single admission is often enough for the landlord to win the case. In eviction proceedings, the landlord's burden of proof is actually very small. They only need to prove 3 things. There is a lease, rent was due, and the rent was not paid. Once those 3 elements are confirmed, the judge typically has very little room to rule any other way. Even if the tenant offers to pay the entire balance during the hearing, the landlord still has the legal right to proceed with eviction. That's why eviction cases move so quickly compared to other lawsuits. And in this case, the judge is about to calculate exactly how much money is owed.
To this point, I was hoping to get to the amount so I could pay it and stay and make this go away, but I guess that's not why we're here. So this was a hearing.
Well, Mr. Merritt, it is the hearing, but the burden of proof for the landlord is pretty minimal here. So if they establish that there's a lease, and there's no denying that, you've acknowledged that there's a lease.
Yeah.
If the rent is due on the first and it has not been paid, that is literally all the landlord has to prove to be able to evict you. Even if you today gave them all the money, plus interest and extra payments, the landlord has still proven their case and can evict you.
Okay.
Okay. Now, that doesn't mean you can't still negotiate or reach out to the Bell South Lamar. I will give both parties some information. Let me conclude the case, and then I'll give Mr. Marriott you information and Ms. Garza, and then y'all that may give y'all some extra stuff that you may wish to do. Okay. All right. So the judgment would be for February and March, and for March you only want 167. So the amount that I'd get would be $1,896. So that would be the judgment for the plaintiff. Back rent of $1,896, and then the cost of court. Either party can appeal. It would be equal to 1 month of rent. So that appeal bond would be $1,729. Now, Mr. Merritt, the number that I've just awarded, the $1,896, that's just February, the whole month, no late fees, and 3 days of March rent. Per the lease, you probably owe the whole rent already for March, right? So the number that the landlord will give you will quite likely would be higher. It would be both months of rent, and they might include late fees, utilities, anything else the lease says you owe. The law in Texas says that in an eviction, the landlord is here first to get back possession of the property and then back rent. And so they can only seek actual rent, which is why the landlord only asked me for 3 days and they didn't put any late fees in it. So that's to explain the difference between the judgment amount and what the landlord will likely give you as a bill, right? Now, you have 5 days to appeal my decision before this judgment of $1,896 becomes final. If in that 5 days, you reach out to the landlord and y'all negotiate. Sometimes I have landlords say, listen, if they just give me all the money, I'm happy to set this aside or vacate the eviction. But legally, they do not have to do that, Mr. Merritt. You could offer all the money and the landlord legally can say, no, you breached the lease, you didn't pay it on time. I wish to keep it as it is. All right. What I'll just say, Ms. Garza, and you've probably been here for the docket and heard this, if y'all come to some resolution and you wish as the plaintiff to set it aside, let me know by the end of the 5th day and we still have that authority. After that, I'm out of luck. I can't do anything for y'all. Okay. You can also appeal. If you appeal, then this judgment is void and it goes up to the next court, and then you'll kind of get the same thing again with a different judge. All right. Mr. Merritt, does that give some information?
Yep, that's good.
All right. Again, then all parties are excused. You have at least 5 days to appeal, or if y'all come to some other resolution, notify the court of that.
Perfect. Thank you.
All right. Thank y'all very much. Y'all have a lovely afternoon, or
Okay.
have a better afternoon.
Right.
All right. Thank you. Ms. Den, why is this eviction filed?
Non-payment of rent,
All right. What's the month? Is there monthly rent? And if so, how much?
September, and then state hasn't paid since September, 1099 is the rent.
All right. 1099, and it remains unpaid since September.
Yes.
Is there any subsidy from the government?
No.
All right. When was the notice to vacate given?
This one was given 2/5/226.
Was that a 3-day or a 24-hour notice?
It's a 3-day.
Okay.
They're not, yeah.
And then was that just a vacate, or was that a pay or vacate? Well, it doesn't really
It's a-
matter because you'd already been late since
And
September.
I already gave them another one, yeah.
Yep, you're totally fine. Okay. All right then. Good afternoon, Mr. Garcia.
Hello.
Thank you for being here. Ms. Den's here. She represents the landlord, Cherry Hill. And she said this, as I often hear, these cases are a financial situation, which is no fun for anyone, but it does happen. So my first question, Mr. Garcia, is the monthly rent amount correct? Is it $1,099?
Correct.
Okay. And then she says rent remains unpaid since September. Is that also accurate?
Yes, ma'am.
All right, well, Mr. Garcia, with that information, the landlord wins their case today. But certainly this is a chance. If you have questions, I want to give you numbers, deadlines. This is your opportunity. immediately, do you have any questions that you are ready or you want to ask?
Yeah, what is the final day I have to be out of there?
Okay, Mr. Garcia, that's a great question. And people love lawyers and judges because I can't tell you the date. I can tell you how to figure it out. Isn't this a fun one?
Okay,
Okay, Mr. Garcia, this is how it works. If you look at your calendar, tomorrow is day 1. You have 5 days. If when
okay,
you count forward on the calendar, 1, 2, 3, 4, 5, if the 5th day happens to fall on a weekend, you get till the next day. If
okay,
it
so
falls
it
on a
would,
day that is a national holiday or a state holiday, and I don't know what next week is, but there might be some sort of a holiday.
it's daylight savings on Sunday.
No, that's not one of them. It's got to be
Okay.
like LBJ Day or Texas
Okay.
Independence Day or the 4th of July, a day that the business that the state is taking a holiday.
Okay,
Yeah, I don't see any next week. If the 5th day falls on a weekend or a holiday, you get till the next day. So I'm not allowed to help you figure out if it's March this or that. I can only tell you that it's at least 5 days. And so, Mr. Garcia, when you're done today with us, if you want to know exactly what date you have, you can call any of those legal aid phone numbers on our website and say, hey, I got evicted today. What's my deadline? And they will literally look at the calendar and tell you. But
okay,
as the judge, I'm not allowed to.
okay, that sounds good.
Okay. All right. Let me give you some other information, though, that you would want to have for that. So I get 1099 is the month. Okay. So September, October, November, December, January. I got 5 months at the full amount. And February, 6 months. September, October, November, December, January, February. So 6 at the full rate of 1099.
This third case shows just how quickly unpaid rent can spiral into a massive financial judgment. The tenant here admitted something very significant. Rent hasn't been paid since September. That's 6 full months of missed payments. Once the judge begins calculating the total, the numbers stack up fast. September, October, November, December, January, February, plus the prorated days for March. By the time everything is added together, the total hits $6,700. And that's not even the end of the pressure. The tenant now has only 5 days to either appeal the decision or move out before the landlord can request a writ of possession, which allows the constable to physically remove the tenant and their belongings. It's a tough situation, but it also shows how strictly eviction timelines are enforced.
Is 65.94. And then for March, there are 31 days. So I'm getting $35 a day. We got 3 days plus 106. So 106 plus the 65.94. Total, is that right? Oh, it is. The total judgment that I calculate is $6,700, flat and even. Okay. So Mr. Garcia, the judgment is for $6,700. Either party can appeal. For appeal, the appeal bond will be twice the monthly rent. So that's $21.98. Mr. Garcia, if in the next 5 days you wish to appeal, you could either pay the appeal bond or file an affidavit of inability. And then if you wish to stay in the apartment while the case is going to be transferred to a new court, you have to pay $10.99 and you give that to us, not the landlord. We give you an exact deadline when the money comes in, okay?
Okay,
If you don't do any of that, on day 6, the landlord can seek what's known as the writ of possession. It's issued by the court, and then the constable notifies you that if you haven't left, they're going to oversee the landlord removing you and your items. Okay?
okay,
You got
understood.
at least 5 more days beginning tomorrow. All right. Good luck to everyone. Then if there's no other questions, all parties are excused.
Okay, thank you, Your Honor.
Thank you very much. Good luck to everyone.
What makes this courtroom session so fascinating is how 3 eviction cases can look completely different depending on the circumstances. The first case showed us a rare legal puzzle involving foreclosure and tenant rights, and surprisingly ended with the bank choosing compassion and cooperation over eviction. The second case demonstrated how quickly eviction law works when rent goes unpaid, and how even a tenant willing to pay the balance can still lose the case. And the third case highlighted the financial consequences of long-term missed rent, leading to a judgment of $6,700 and a strict 5-day deadline before removal proceedings can begin. These hearings remind us that eviction law isn't just about contracts. It's about timing, legal obligations, and sometimes life circumstances that complicate everything. But now I want to hear from you. Which case surprised you the most? Did the bank make the right decision in the first case? And do you think eviction laws are fair or too strict? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, And don't forget to subscribe for more jaw-dropping courtroom breakdowns. Because trust me, the next courtroom story might be even more unbelievable.